I'm Sarah Wakeman, Fundraising and Business Development Manager at Carers Society of England, and today I'm joined by Richard Dundee from Wright Hassall. Hello, Richard.
Hello, Sarah. How are you?
I'm good. How are you?
Good. Yes, not bad. Excited to be here again. Well, for me, it's the second time. For you...
This is my first time.
Yeah, so we're at 1 Mill Street Studios in Leamington, which is a very fancy podcast studio.
It's very fancy. It's very nice.
It is, and the coffee's not bad.
The coffee's amazing.
Which is good. And you're going to grill me on powers of attorney
I
today.
am going to grill you on powers of attorney
Good.
today. We would really value your expert opinion and advice. One of the biggest things I think for me, particularly going through the carer journey with my mum with dementia, was what's the power of attorney? When should it be kicked in? All those ethical, questions that you have around it, and you've got to do it, but it's a big decision. And just, I think, for us to be able to take the pain away from those kind of decisions will really help people. So
I agree. And it's like most things in the legal world, unless someone's specifically spoken to you about it, a lot of people know a little bit, but not everybody knows truly what the position is until they've sat down with somebody that deals with it day to day. And I'm hoping that our conversation today will shed some light on some of the weird and wonderful things with powers of attorney, and guide the people that you speak to and guide the people that listen to this podcast about their uses and why they're so important to have. That's the objective.
fabulous.
And I hope we have a giggle on the way. I'm sure we will.
I'm sure we will too.
I'm like an excitable child today, Sarah. Can you tell?
Definitely, I love it.
Good. So just to let you know who I am, so I'm a partner at Wright Hassall. I specialise in private client, which means nothing. All it means is I deal with wills, powers of attorney, probate and trusts. So trying to get everybody's ducks in a row, get all the planning sorted to make the transition from birth to death, which is a really horrible thing to say, as smooth as possible. That's the objective. And powers of attorney play a really important part of that. We hope, of course, that no one ever needs to use a power of attorney because we'll retain our faculties, our capacity until we go. But it's a really nice insurance policy to have. It's something you keep in the bottom drawer and you hope you never have to put it out. That's a power of attorney in summary. Should we talk about why you might need it?
Yes.
Should we start there?
Yeah.
So you mentioned that you have some experience of powers of attorney in the past. I'm lucky that I haven't yet, but I'm sure at some point in the future one of my family members may start to lose physical or mental capacity. Give my dad a drink on a Saturday night and his mental capacity disappears quite quickly. But that's not what we're talking about here. That's just dad liking his whiskey. He doesn't actually. He likes his lager. He'll hate me for saying he likes, but he hates whiskey. It tastes like ash, is what he says. So we all hope that we will be perfectly fine until we die. And we hope that we'll die quietly and safely around our friends and families. But the reality is we don't know what's going to happen from day to day. So I could walk across the road today, get hit by a bus and be completely incapacitated. And the question then is, well, who's going to deal with my house? Who's going to deal with my money, paying my bills, look after my financial interests, make sure that the phone bill gets paid so the broadband gets kept on, make sure that if I'm a business owner, the salaries can be paid and the suppliers can be invoiced and the work can get done. If I've not made it plain who I want to help me in with those issues, then unfortunately there is nobody that can help me. Now we'll talk about what happens in that scenario later down the line.
Okay.
But the advice is always make it absolutely plain who you trust to deal with your affairs, and do that in the form of a power of attorney. Now, I could make a power of attorney sound really fancy, Sarah, if you want me to, but actually in reality it's just a bit of paper.
Okay.
Shouldn't say that as a lawyer. I should make it sound really mystical, shouldn't I, and fantastic, but it's not. It's a piece of paper that you fill in that says, I trust you. And if that person's not here, I trust somebody else underneath. And should the worst happen to me, they can help me. They legally can step into my shoes and deal with my affairs. There is a presumption You have to stop me, by the way, if I keep babbling on. You're meant to join in, Sarah. I'm just talking.
I'm blown away,
Okay,
Richard.
good. There is a presumption that my wife would be able to help me. And if I don't have a wife, my children might be able to help me. Or if I don't have children, my parents should be able to help me. So there's always this presumption that there will be somebody that can take the lead and deal with it. But in law, the reality is that that's just not the case. So it's really important, no matter what your age, whatever your relationship status, whether or not you've got children, it's really important that you make it absolutely plain that I want that person. So how do I do it? Well, before 2007, I'd have completed what's called an enduring power of attorney. 4 or 5 pages long, exactly the same process. I pick you, Sarah, to be my power of attorney.
Okay.
I trust that you'll do the job right. Sign the bit of paper, you sign the bit of paper, and we stick it in the drawer. Nowadays, since 2007, we can't make enduring powers of attorney anymore. They're lasting powers of attorney. Same idea, I trust you to act on my behalf, but the form has become a lot longer. Still a process of you signing and me signing, but now there must be somebody to confirm that I have relevant capacity.
Right.
So that might be the person that's preparing the document, the solicitor, the lawyer, or it might be somebody that I've known for a period of time that can confirm that I'm okay to do this. So very much a form-filling exercise. The key thing with a power of attorney is that I trust the people that I'm appointing. If I don't trust them, they're not the right people for me.
Okay, that makes perfect sense.
Good. Why would I want somebody to help me? Well, a lot of people don't want anybody to help them at all. And that's key to this. I'm not suggesting, and no one would ever suggest, that by making a power of attorney you're giving away control. You're not. You're preparing for the future. And that's one of the concerns we hear. One of the reasons people don't make powers of attorney is because they're worried that if they sign these documents, they're effectively relinquishing control of their finances to another person. That's not the case. As long as it's made correctly and you put appropriate safeguards in place. So the safeguards that we always talk about is making a power of attorney with a professional to make sure, or so they can make sure that you're not being unduly pressured.
Yeah.
Taking you to one side and saying, Sarah, are you absolutely certain that this is the right person for you? Are you certain that this is something you want to do? And then when the document's prepared, locking it away. You know, if you go to a solicitor, they'll store it for free. They'll keep it in their safe and they won't release it to anybody else until they have confirmation that you're happy or that you've lost capacity and they need to be able to use that document. So it's really important that, one, you make it, and two, you've got appropriate safeguards in place to ensure that it can't be accidentally accessed.
Okay. So is there just one power of attorney?
Good question. I was about to take a sip of my coffee and you've thrown another question at me.
There you go.
So there's two.
Okay.
And this sort of leads me back to what I was saying before about enduring powers. So we used to be able to make an enduring power of attorney pre-2007, and that was purely focused with your property and your financial affairs. So by that I mean my money, my house, paying my bills, making sure there's a roof over my head. 2007 came about and they realised there was a gap, and that gap is health and welfare. So money isn't everything. I need somebody to make decisions about where I live, about what treatment I receive, what medication I might have, and that horrible idea of end of life. So who can make the decision about turning off the life support machine? Not something we want to think about every day. The property and financial affairs document doesn't cover that.
Right.
So it might allow your life to continue, the bills get paid, the money comes in, the money goes out, but it doesn't deal with these highly emotional issues, sensitive issues over here. So the government changed the rules. You now have two documents: property and financial affairs, power of attorney, health and welfare, power of attorney. They both, as I say, deal with very separate issues that you might want separate people dealing with.
Okay.
So what I mean by that, Sarah, is I might trust my wife. Now she'll listen to this. So Shelley, I do trust you. Of course I do, she's my wife. but I might want her to deal with my money and my financial affairs. She knows where the money is, she knows what bills need to be paid, but I'm hoping that she'll be so distraught by my lack of capacity and grieving so much that she won't be able to make decisions about health and welfare. So I may choose to appoint my dad or my sister to make those decisions, knowing that they'll honour my wishes about treatment, where I live and end of life. Decisions that I wouldn't necessarily want my wife to make, because I feel that she wouldn't necessarily be able to make the correct decision at the time due to the close proximity she has with me and my children. You understand what I mean?
Yeah.
I hope she's not listening now. I'm going to get a slap on the wrist, Sarah, I really am. But the point is, I might choose different people to deal with different things at different times. I might have the same person. So I might pick my colleague Stevie to deal with both aspects, knowing that she will ensure that all my wishes are dealt with in the correct manner. The issue with appointing one person, of course, is that something might happen to Stevie. So I might say, well, I'll have two people to deal with all my affairs, or I might have some replacements to step in the event of them going. So these documents can be structured in lots of different ways, but the important thing is there are two. We recommend that you make both, because by making both, you're covering off all aspects of your life that might need somebody to step in and help.
And I suppose that with the health power of attorney side of it, you want people that know you.
Precisely.
That know you really well, that would know the decisions that you would make about yourself if you had capacity, if you weren't in a position to be able to make those decisions.
Absolutely, and that's spot on. It's very easy to look at someone's bank statement and say, right, the BT bill is this, we've got to move money from here to here, or the house has to be sold, we're going to sell it for the market price. Those decisions can be difficult logistically, but they're actually quite black and white, aren't they? They're very plain. But whether or not I would want this treatment or that treatment, whether or not I would want to drift off or keep going, CPR or no CPR, do I live in this care home or that care home? They're very, very personal choices, very emotive choices, ones that I would want to really sort of hit home with my attorneys and make it quite plain what I would want them to do. So they require a lot more thought, and they require, as you say, someone to know me. It's not just a bank statement with some money moving in and out. So I would focus more, we always advise our clients to focus more on sitting down with your attorneys in respect of health and welfare than we do with property and financial affairs, for obvious reasons.
Yeah. So in a situation like mine, for example, where I have two teenage boys, obviously in terms of the financial, that would be really easy because it would be a 50-50 split.
Yeah.
So not a problem at all. However, boys being boys, with due respect, Richard, boys are boys, and I would definitely want my sister
I don't know what you're saying.
to be involved to make sure that they, because I know my children, you know, they say now that I'm losing it and I need to go into a home and be looked after. So, you know, in another 20 years' time, I'm thinking that I really do need to have that third person that's wiser and female to make sure.
They need to be careful, though, because you feed them, I assume.
I do.
So, you know.
I do. They do need to be nice.
They do.
They do. But obviously, it would make sense to me to make sure I'd got that older, wiser
Absolutely.
guru that would know exactly what my wants and wishes are involved in that. But she wouldn't necessarily then need to be involved in the financial one because that would be a straight split as such.
And even if you had, so in your example, your two boys and your sister, acting on both capacities, so money and finance and health and welfare, that doesn't mean that all of your attorneys need to act at the same time. So I might appoint yourself, my colleague Stevie, to be my finance attorneys, property and finance attorneys, but Stevie might go on holiday to Miami, which would be nice, for a couple of weeks. Something needs to happen. Does it require Stevie to be present at that moment in time? Well, if it's prepared correctly, if the document's prepared correctly, it can be that you can act independently. So in your example, your two boys, as long as you trust them, can deal with absolutely everything completely without any assistance from your sister, unless your sister wanted to join in.
Right.
So they can act joint and severally is the term that we would use in the profession. So everybody can come together and make decisions, or one or two can go independently and make decisions on their own. Now, that sounds great, but it also sounds terrifying, because what happens if you've got a rogue attorney making choices or accessing bank accounts, that the others wouldn't want?
Or if they've fallen out.
Well, the easy thing for me to say, Sarah, is only appoint good people. And the problem is, how do I know that the people I'm going to appoint are going to be the right people in 20 years' time?
Absolutely.
There's no answer to that, unfortunately. It is what it is. So you've got to think long and hard at the beginning. Now, you can, of course, change your mind and amend the document, or more particularly, scrap it and start again at later stages. But you can only do that whilst you've got capacity. If you don't have capacity, you're stuck with the people that you've appointed. If they're a bit silly and they do naughty things, then there is a possibility of forcibly removing them. So in your example, if your sister started doing things that your sons weren't happy with and they were against the law or against your best interests, then the other attorneys could contact the Office of the Public Guardian. So that's the regulatory body that looks after these documents, explain their concerns, and they would then do safekeeping and make sure that your sister's not up to no good. Worst case scenario, she gets pulled away and she's no longer able to act. So there are security measures in place, but really a lot of damage could be done, before you get to that stage, which is why we stress that people need to absolutely trust the people they appoint.
That's really helpful. So when is the right time to actually be having the discussions? I was lucky for me in the fact that my stepdad had been diagnosed with Parkinson's.
Yes.
And had the foresight to put things in trust, his side of our estate into trust for the four of us, at which point the power of attorney was written, and Mum did hers at the same time, not knowing that 15 years later she'd get a dementia diagnosis. So we were lucky in the fact that that was all there. But for me now, at my age, coming up to 50,
Don't lie, 25.
I wish. No, I wouldn't. I have not got one, so it now seems actually that I should.
Yeah.
Now is probably the right time for me, whilst I'm still got all my faculties to do it.
The proper lawyer answer is everyone should have one. From the moment you turn 18, you should sit down with your lawyer and make a power of attorney. Now, you try and tell an 18-year-old that they need to go and see a solicitor to make a power of attorney, to think about them losing capacity. They'd give you that look, Sarah, the look we both know, and they'd go, no, I'm nipping down the park with some Frosty Jacks. Me and Stevie were talking about this earlier. There's no chance that they're going to sit down and make that document. But they should, because we don't know if they're going to get hit by the bus. We don't know what's going to happen to them. They may lose physical or mental capacity, and they need somebody to help them. And that's what that document will do. Now, in reality, it's the older generation that worry about this issue because they have business interests or they have property or money, because they see their parents slowly slipping, and they realise, actually, this is going to happen to me at some point. Now, we still get an awful lot of people in their 90s that haven't prepared powers of attorney, and they go, right, now's the time to do it.
That's fantastic, though.
Oh, absolutely. And I'm all for it if they've got the ability to continue acting on their own behalf and doing absolutely everything that they should. The problem is we just don't know when that ability might slip away. So the advice is, have it, do it, register it so it's usable, and then stick it in the drawer or lock it away in the safe, knowing then that if a surprise incident of capacity happens, if you suddenly wake up in the morning and you can't help yourself, it's done. That leads me nicely onto the issue of, well, what happens if you don't have it? Because that's the other thing, isn't it? If we don't have this in place, if people don't heed my advice, the 18-year-olds don't come and see me and get this document done, what happens if I do get hit by the bus? Or I go on holiday and I catch an illness and I lose capacity, either temporarily or permanently. What happens next? Who can help me? I've already said it can't be my wife, automatically. It can't be my kids. It can't be my parents. They have no legal ability to access my bank accounts and do various things. What they would do is they'd have to apply to the Court of Protection. So this is a deputyship application. And ultimately, it's someone that you love, or a friend, or somebody that feels responsible for helping you, going to the court, cap in hand, effectively, and saying, I really, really want to help this person. Can you make me the person in charge of their affairs? Now that's quite a long-winded process. We could speak for an hour, Sarah, just on deputyship.
And I would imagine it's very time-consuming and takes...
And expensive.
Yeah.
You know, the court fee alone is a lot more than it would cost to prepare a power of attorney. You then have the solicitor's fees in dealing with it. Plus, on top of that, you've got annual reporting requirements. So the court's not just going to say, right, Sarah, you're the right person to look after Richard, off you go. They're going to want to check in every year. They're going to want to know how much you've spent year on year, down to the penny. They're going to want you to do this and do that. So it's very, very rigid. Now, I don't mean that to come across in a bad way. That's a good thing, because you want the courts to keep an eye and make sure that the person that they're appointing is doing a good job. Power of attorney is slightly different. If I appoint you, Sarah, to be my attorney, there is no requirement for you to inform anybody.
The trust is there.
Because the trust is there. I have picked you. The court have very little trust. They want to ensure that you're doing a good job. Now that comes with cost, time and effort. Plus on top of that, it's the court appointing you, not me. So if I've not made it plain to my parents and my family who I would want, then it could be any of them that go and say they're the right person. Now they might not be the right person. You see what I mean?
Absolutely.
So it falls on somebody else to put their hand up rather than me saying, no, put your hand down, you're not the right person, you are.
So it makes sense to absolutely get it sorted as soon as you possibly can then.
Financially, makes perfect sense. Logistically, makes perfect sense. And to ensure that the right person is dealing with it, it's 100% the right thing to do. The problem is, I can say that until I'm blue in the face, but there's still this perception that nothing's going to happen to me.
Right.
It won't happen to me. I know it will happen to somebody else, and that's really sad. But I'm not going to lose capacity. I'll be fine. And 70% of the time, those people are correct. But horrible things happen, unfortunately, to good people. So it's like why we have home insurance, isn't it? We don't take home insurance out because we think the house is going to get set on fire. We take it out just in case.
And why would you not want to protect your own wishes
Absolutely.
and well-being?
Well, this is it. And I don't know why people choose not to do it, because it's absolutely the right thing. I think people are worried about the cost of it. I think people are worried about spending the time thinking about it. So we still have this belief, normally with wills, but also with powers of attorney, that if I start doing it, then I might be tempting fate. And I hate that expression, but it's still there in the back of the mind, in the psyche of a lot of people. Obviously, you and I, Sarah, both know that that's not true.
Not true.
It's the same, as I just said, with home insurance. Me taking out a policy of home insurance doesn't mean the house is going to burn up. It just means I'm making sure that if it burns up, something's there to cover it off, and I've got somewhere to live.
From talking to people, even family members and friends, a lot of people don't fully understand what that power of attorney actually means, though.
Yeah.
Some friends, for example, they are the same age as my mum, who I met recently, and they've got nothing in place, and they hadn't realised that their daughters can't just go and activate it without medical intervention, and that it is there as a safety net to help them.
Absolutely.
And I think if you love your children and you want the best for your children, you want to make everything as easy as you can for them, including what your wishes are. And obviously you've got that in your will, but particularly with when it comes to hospital treatments, if you lose capacity, it just makes sense that if you love your family, you don't want to burden them and you want to get everything in place. I
agree wholeheartedly. And people always think, as you've touched upon there, I've got my will in place, I don't need to do any more. Now, I would argue a will is an incredibly important document. Of course it is. That's my livelihood. Wills are really important. Get a will, everyone. But powers of attorney are more important. They are the most important document I can make for you, or you can make yourself. Because I know I'm going to die. Unfortunately, Sarah, so are you. It's going to happen. Hopefully not anytime soon. We can't go back. We can only go forward, so they say. But I don't know if I'm going to lose capacity. But if I lose capacity, my entire life can shatter around me. So I need something there to try and prevent that shattering from taking place. I can't stress enough how important it is.
So we have power of attorney. It's all set up. It's ready. In our instance, it was very clear that Mum was losing her capacity to be able to make decisions. And we've got this document, and we know that we need to be recognised as the people when we talk to doctors, etc. Because she wouldn't remember those conversations. We had to be there. We needed to be those people that they dealt with first. What happens then? What do we do with the document?
Yeah, it's a good point. So we've got it. It's there. It's registered, which is an important point. And let's just jump on that quickly. If you sat down with me today, Sarah, and we made a power of attorney, there is no obligation on you to have that document registered straight away. Now, the process of registration is sending that document you've signed off to the court and they stamp it. Now, that can take a long time, which is why we recommend you register it now, before you've lost capacity, rather than waiting until you lose capacity and not being able to use it for, say, 20 odd weeks, which is the time frame that it takes for them to stamp and send it back, if not longer. So you get that done. So let's pretend that we've done that, we've registered it, it's there. It appoints your 2 boys to be your attorneys. You wake up in the morning, capacity's gone. So what do your boys do? Well, they're going to want to be able to continue your bills being paid. So they take that document down the bank and they hand it across. They make sure they get it back. There's no offence to the banks out there, but they have a habit of keeping documents and you'll never see it again. So you hand it to them, they photocopy it, they hand the original back to you. They log on their system that, they are now the right people to deal with. They may, of course, ask to see proof that you can no longer act on your behalf. So that's where a doctor's assessment would come in, a capacity report confirming that you no longer have capacity. And that's what we would ask for. So if your boys knocked on our office door and said, Richard, you know how you made a document for Mum many years ago, can we have it please? I'd be saying, absolutely you can, but prove to me that Mum can't come and get it herself. So I'll go and ring Mum, or you get a capacity report in my hand. So that's an added safeguard, which is what you would want, Sarah, absolutely, isn't it? Because although we trust the boys, of course we do, there are reasons why they might find themselves in financial difficulties, see your finance as an option to get out, and solve their problems. So you want those safeguards in place. But as long as they can be satisfied, ultimately they're going to hand it to the right people and they step into your shoes. It's as simple as that.
I think one of the biggest things is knowing when the right time is.
Agreed.
To activate it.
Now
as such.
The property and financial affairs one is special compared to the health and welfare document. So the health and welfare, and just to recap, that's dealing with your medication, your health, where you live, and end of life. That can only be used by your boys once you've lost capacity. So that's mental capacity, that's gone. And they have to prove, as we've just said, that that has happened. Now that's normally a very obvious moment when you can no longer make those decisions for yourself. And I wouldn't want my wife or kids making choices about what treatment I had if I could make those choices. That makes perfect sense. The property and financial affairs document, however, is a bit more flexible. So I could wake up one morning, be perfectly fine, but really don't feel like going down the bank. I could appoint you, Sarah, to be my attorney. I could hand that document to you and you become me. So it can be used with consent, ultimately.
Right, okay.
Now, if I should lose capacity and you can prove I've lost capacity, then you can take that document and use it at will. You are now me for all intents and purposes. But also, whilst I have capacity, I can hand the document to you and say, Sarah, be me for this limited episode here. Go and do that thing. Or if I'm on holiday and I want to sell my house, Sarah, you're now me. Get it done. I want it sold before I come back from Miami or somewhere nice. I haven't been anywhere nice this year, Sarah, can you tell? I'm desperate to go. So really flexible, but flexibility can sometimes equal danger.
Yeah.
So this is, once again, I trust the right people, I hand it to them and I demand it back. Here you go, Sarah, go and do this. I expect it back on my desk by the end of the day. If you don't give it back, then I start to get a little bit worried.
But then if I had got a disability and leaving the house was very difficult.
Perfect.
you know, if we entered a pandemic again and I was vulnerable and I didn't want to go out and be around other people, that could be a really good option.
Really, really flexible option. A lot of people say, well, I don't need that because I've added my mum or my wife or whoever onto my bank accounts as a third-party signatory. And that would work to deal with that particular account. But you can't do that for everything. You can't do that for the phone bill. You can't do that for the house. You can't do that for the car. A power of attorney covers off every financial sort of decision I might need to make. So effectively today, Sarah, become me. Do all my washing. Make me dinner. I'm joking. Deal with all my bills.
Poor Shelley.
I know, poor Shelley. Don't feel too bad for her. She lives a happy life. Become me. Help me. So really, really useful thing to have, as you say, in circumstances where I'm just not able to, either because I don't want to, which some days I don't feel like doing anything, or I might not physically be able to. So I need help. I've still got capacity, so I can make those choices, but I physically can't go out and deal with these issues I have. Go and do it for me. As long as I trust you, and I give you the document and you hand it back, and I can lock it away again, it's a really useful thing to have.
And I think the same for us as a family with the health and welfare. That's where that was really useful because, you know, Mum didn't look as if she got any problems and she was answering the right questions, but we as her family knew. And that document allowed, well, it meant that we could say, actually, no, you're talking to us. We want to speak to you.
Precisely.
You don't talk to Mum, you talk to us. So it meant that in terms of the medical profession, they had to talk to us so that we could make sure that everything was put in place and that the medication was right and the appointments were right, etc.
Quite right. And it comes back to this assumption that a lot of people have that I don't need it because of course they're going to deal with me. Of course I'm going to be able to step in. That assumption is wrong. You know, they will simply sideline you. So you've got to have it in black and white. You've got to have it there. A lot of professionals, of course, doctors, carers, will try and involve the family. But when push comes to shove and the decision needs to be made, if you've not got the correct legal documentation, unfortunately your voice will not get heard. And that's really important for a person to understand if they want somebody else to have the voice for them.
Yeah. Okay, so obviously we've touched about making sure that you've got people that you trust. So for us it was easy. There were 3 siblings, so all 3 of us had the same power of attorney rights as such, so we all had an equal share of it. If there was only one person, but you did trust them, but you want to make sure that that one person is doing the right thing, is this where you as the expert and the legal person can work with that person as well?
Absolutely.
Okay.
So you could. Now we never recommend it in the first instance. So professional attorneys, as the name would be, they're there to step in and assist and make those decisions normally when there's nobody else. So in my circumstance, or in your circumstances, Sarah, I would never be advising you to appoint the firm or your accountant or your IFA to be your attorney, because you've got good people. You've got your boys, you've got your sister. So why would you or your loved ones incur the cost? Because there's always a cost to professional acting, of course there is. Be naive to think otherwise. Why would you appoint somebody that's going to charge fees to do the same job? Now, in the limited circumstances where people don't have anybody they can trust, or the only person I have is somebody that's of a similar age to me. Now, I say that because chances are if I'm losing capacity and I'm a certain age, the person I'm appointed, who's a similar age, might lose capacity or die at a similar time to me.
Yeah.
So I want an assurance that there's going to be somebody there at all times. So that's when having a professional on board who can step up to the plate at the right time, in the knowledge that it might cost a few quid down the line, but in the knowledge that they'll always be there, is a really useful thing. Plus, on top of that, they're completely unbiased. You know, a professional attorney has no vested interest in making sure that these monies aren't touched or this asset over here isn't sold. They're going to look after your best interests in whatever way, shape or form. One, because their PI is on their line, their insurance is on their line. They need to make sure that they're doing the job absolutely correctly. Whereas a lay trustee, lay attorney, I should say, wrong thing there, not a trustee, attorney. They're doing the best job they can possibly do. Of course they are. They're looking after your best interests. But if they make a mistake, no one's going to be breathing down their neck necessarily, unless they make a really, really bad mistake and then the regulator gets involved. So a professional attorney will do absolutely everything to the nth degree in the knowledge that they could possibly be shouted at if something goes wrong. Is that?
Yeah, that makes sense.
Good.
So is there much responsibility to being an attorney?
A huge responsibility, and it is a huge responsibility. The overriding principle for an attorney is that they must look after the best interests of the donor. So the donor is the person that we're talking about. So you're the donor in this case. You've given me the authority to act as your attorney. So I've got a duty to act under your best interests. And when you make the document, there's a page that goes through the Mental Capacity Act and all the various things that I as an attorney must consider before I make a decision on your behalf. And that best interest principle is written there twice, once in bold, just to make it really clear in case you missed it. So that's the overarching principle for any decision I make. Is this in Sarah's best interest? I must also consider whether or not I can help you make a decision for yourself. So being your attorney in this hypothetical scenario, Sarah, because I'm not your attorney, am I? I don't think I am.
No, but I do need to do my power of attorney, so maybe
So you shouldn't admit that on a podcast about powers of attorney, but we'll get it sorted. Good. Hopefully I've convinced you. Good. So the other thing, apart from looking after your best interest, I must help you make as many decisions as you possibly can. I can't take over. Now that's one of the things I was saying earlier, why people don't make them, because they're concerned about, well, if I appoint Richard to be my attorney, I've lost complete control. He's going to take over, he's going to sort everything. That might be a good thing, or for a lot of people it's a bad thing. Actually, no, I want to continue doing these things. As an attorney, I'm not allowed to do that. Now, as a professional, I know I'm not allowed to do that. A lay attorney, your children, your friends, your relatives, they might not understand that unless they've been told specifically. Once again, another reason to go to a professional to make these documents, to make it plain to your attorneys what their obligations are. So it's highly regulated in a sense of your attorneys can't just come in, take over, push you to one side and say, that's it, Sarah, you're done, I'm taking over. You can stop them if they did that. Of course, only whilst you've got the capacity to do so.
And it is ultimately about the capacity, isn't it?
Of course it is. Yeah. It's all about can you make the decision as to who you want to act and that you trust that they will do the right job. Yeah. If you can do that, you can make a power of attorney. Now, we spoke before this podcast, didn't we, about when is the right time, and people that have early diagnosis of certain illnesses that might then be thinking, or their relatives might be thinking, well, is it too late to make a power of attorney? I sit down with lots of people, as you can imagine, in this job, who have varying levels of capacity. And the key thing for me is that when I sit down and talk about powers of attorney with them, they understand what the document is. So we have a good chat like this and they understand what it means to make one. They have a good idea as to who they want to appoint, and they understand what it means to appoint that person. And importantly, that they trust that that person will do a good job. And thirdly, they have a good understanding of what they actually own. If I start babbling on about how I own a mansion in Belize, you probably know, Sarah, that
that's not true.
It's not true. It's not true. Well, I haven't told the taxman anyway. I'm joking. I don't. I don't.
You'll get into trouble with
you will, absolutely. So yes, it's important that the person that's making it has a good understanding of those three sort of pillars there. Now, I might have a conversation with you today, Sarah, and fully understand those three things and be absolutely clear as to my wishes. Tomorrow, however, that might have gone. I might be having a bad day. I might not know you from Stevie. My capacity might wane, but then the next day it will pick up again. It might be that I'm really good in the mornings and really bad in the evenings. Just because I lack capacity at a certain point doesn't mean I can't make a power of attorney. So capacity can be fleeting, is the point I'm making.
Right.
As long as at the point where you signed the document, you fully understood what it was and you understood what it meant and you had capacity at that particular moment, then you can get it done. Now, of course, for a professional, that can make it quite tricky. So if I sat down with you and you started talking about there being sheep walking around this podcast room, I might be thinking Sarah's not going to be able to make her document. But I might catch you, an hour later and you might be perfectly fine and say, right, when are we getting it done? I need to be able to be confident. I need to be able to document that you're okay, which is why a lot of professionals will ask you or your loved ones to go and seek the advice of a doctor or somebody that can make a report that confirms that you're okay.
Yeah.
And they will run assessments and tests just to make sure that no one can criticise you or me or anybody else. No one can say that you've been forced to make this particular document.
So it beggars belief why we're not doing it. Because ultimately it is, if we live a life a certain way and we have an idea of how we want our end life to be, then you would want it with in the hands of the people that you trust the most, that they will make the decisions that you would make if you're not able to.
And that's it. Summarise. I'm going to steal that. That was really good. Summarise beautifully.
We've got it recorded.
We have. Fantastic. That's precisely why you would do it. And I agree, over the last however many years, more than a decade, I've sat down with lots of people and advised them that the power of attorney is the right thing to do, and they'll still not do it. And they won't do it because they'll believe that it's never going to happen to them.
Yeah.
Unfortunately, it
does.
might. It does. I can't guarantee it because a lot of people will go from birth to death and retain capacity, but you don't want to be the unlucky one. And the cost and the time and the heartache and the suffering that your family will experience of going through the court of protection sort of application and process is just not worth it for the sake of you signing a bit of paper saying I appoint you. It really is that simple and that important to do.
Richard, that's really helpful. Thank you so much.
A pleasure. I'm going to go finish my coffee now, if that's
Excellent,
okay.
me too. Might need to get another one though.
Absolutely. Sarah, a pleasure. Speak to you soon.